Since 1970, marijuana has been a Schedule I drug. It's a label the federal government gives to substances that are considered highly addictive with no recognized medical benefits. My guest, Alex Kreit, law professor at Thomas Jefferson School of Law, joins us with the potential impact of this ruling. And Alex, how unusual is it for a judge to re-examine the classification of marijuana?
Yeah, this is really a surprising thing for the judge to be holding a hearing, because the argument that the defendants in this case are making isn't that much different than an argument that defendants make sort of with some routine across the country. Usually judges have been dismissing this argument out of hand, that there's a constitutional problem with marijuana's classification federally. So for this judge to put aside 5 days to hold a hearing on it, that's a very unusual thing.
What are some of the key arguments for and against reclassifying marijuana?
Well, the main argument I think that the defendants are making is that there's an equal protection problem. There's not a rational basis for classifying marijuana, the plant, in Schedule I, while marinol, which is synthetic THC, which is one of the main constituent components of marijuana, is in Schedule III. So they say, how could that be? How can the synthetic version be in Schedule III, a lower classification, while marijuana is in the heaviest schedule?
Now, just this week, the American Academy of Pediatrics urged the federal government to downgrade, if you would, marijuana to a Schedule II drug. We're talking about natural occurring marijuana. What types of drugs are in Schedule II classification?
Cocaine is in Schedule II, for example. Really, Schedule II, the difference between that and Schedule I is whether there's a currently accepted medical use or not. As far as all the other characteristics, the abuse potential, 1 and 2 are the same. The difference really is, does the federal government recognize that there's some medical use for it? If so, it would be moved to Schedule II.
Isn't it difficult to do research on a Schedule I drug?
Yeah, it's incredibly difficult to research a Schedule I drug because of all the administrative hurdles. When something's in Schedule I, from manufacture all the way down the line from distribution to the researcher, there's additional hurdles that somebody has to go through if they want to research it.
Now, a number of states have decriminalized, some have legalized marijuana, and there's a push here in California to get a legalized pot initiative on the 2016 ballot. What sort of impact would reclassifying marijuana have on the U.S. drug policy? Well,
I think more than anything, it would be another reason for Congress to look at it and step in and finally solve this problem. If marijuana were to be reclassified into the current system, it really wouldn't solve the conflict we have now between state and federal marijuana laws. It would maybe ameliorate it a little bit, but it wouldn't solve it. And one of the reasons for that, especially with recreational marijuana, as long as marijuana is scheduled, whether it's 1, 2, 3, 4, 5, it can't be sold for recreation. Anything on those schedules could only be sold legally for medicine from Schedule II and on. So really, in order to ultimately solve the conflict, I think it's something that Congress is going to have to take up.
There's a criminal case in Sacramento right now that we were talking about. When could we expect a decision on that, and how likely do you think it is that the judge will actually rule in favor of the defendants?
I think that we're probably going to see a decision anywhere from the next couple of weeks to the next few months, depending on how much the judge wants to put into writing out the decision. I think it's unlikely that the judge is going to rule for the defendants, just simply because it is a tough constitutional argument to make. Regardless of what the logic might be from a policy basis, constitutionally, courts typically defer to Congress and to the executive in what they decide. So if it's within the realm of reason, courts are generally going to say, well, I might disagree, but that's not my call. So it's a tough argument to make. There's certainly some chance, but I would be surprised.
So is reclassification and the states that have decriminalized it or legalized it, are these just micro steps to getting to the ultimate, essentially that it's not if it's going to happen, but when it's going to happen?
I think we are sort of reaching that tipping point where it's starting to become, I think, a question of, when and not if. Unless this trend really significantly reverses, the fact of the matter is we're going to have 5, 10, 15, maybe 20 states with recreational marijuana laws by 5, 10 years from now. And when that happens, the reality is the federal law's got to change. It's just not tenable, regardless of what you think about marijuana legalization itself. Even if you're against it, it's not tenable to have this state-federal conflict. It needs to be resolved.
All right, law professor Alex Kreit, thanks so much.
Thank you.